May it please the court, Elizabeth Caddick for Anthony Magri. A person has a reasonably high expectation of privacy in a suitcase, overnight bag, or other container left at a host's home. That is why the federal courts have long held that even if a host gives police the consent to search the host's home, the containers, the bags, left by the guest still maintain a reasonable expectation of privacy by the owner.
Describe these bags.
These bags were a duffel bag, a traditional overnight bag, one would say.
Zipped up duffel bag?
Well, all we know is that the officer who sees them, officers, could not see in them. There was no description that they were otherwise sealed, but when asked, could you see inside them? No, I just took them back to the police department. The other was a bag with rope handles.
Rope handle, you know, like a shopping bag?
Yes,
kind of thing?
yes. But what we know is that you could not, the officers could not see what was inside them.
Did the host have the authority to consent to the police taking the bags?
Well, I've not found a case where the seizure itself has been challenged. Usually in these cases, the bags are seized and the court doesn't appear to have a problem with that. It's the search once they're seized that seems to be an issue. And the issue of their seizure was not raised below. So it does appear to be that it's the search themselves. There's certainly no court has held that the police have to stand outside the host's house and wait for there to be a search warrant in order to seize them. So.
Let's assume for the moment that you're right and that the seizure should not have been based on the consent. I gather there were only 4 counts that had things in these bags that were alleged to be stolen. Would a finding in your favor have any effect on the other counts?
Yes, and actually there are 6 counts. By my count, 5 are clear on the record that they apply. There's the 3 counts dealing with Maria Montero because her credit cards and personal belongings were found inside the white bag. There are 2 larceny counts, one the knife stolen from yours, mine, and ours, and the camera, razor, and I forget what else, something stolen from Brooks. There are a couple of items, 3 items stolen from Brooks. And they're clear on the record. Also, the 6th count is the watch or watches by O'Connell, and that's count 2. And what we have is that O'Connell testifies that he was brought to the police department and they show him a backpack, a bag, and in that are his watches. And in the defendant's memorandum of law in support of his motion to suppress, he lists the items that were seized by the police, including the watches of Scott O'Connell inside the bag. What is not in the record is the police report that clearly states that the watch of Scott O'Connell was taken out of the backpack. And one of the problems is this was not done the right way. Had there been a search warrant and a search warrant return, we would know clearly what was in there. But what we have are 6 counts, counts 2, 8, 12, 14, 16, and 18, and they deal with a wide range of charges. They deal with receiving stolen property from 2 different victims. It's receipt of a fraudulently obtained credit card, identity fraud, and counts of larceny. And those larceny counts were, we don't know if it was necessarily these, but the larceny counts made up the common and notorious thief conviction. So I argue that there is prejudice because it is evidence that you can see, and unlawfully admitted evidence that he committed these various crimes that he was charged with. And what they have is this hard evidence that he committed these crimes, and would lead the jury then to conclude that he committed the other charges against other victims of the same crimes. And what's also important about this hard evidence is that there were 3 charges that he was acquitted of, and those 3 charges, the only evidence that he committed them came from the 2 testifying co-defendants, who the jury obviously did not believe, and they acquitted him on that. Whereas the other evidence that came only from these testifying co-defendants, but there was this hard evidence, they then convicted the defendant of. So it is prejudicial because they used that for the other crimes also. There's no exception to this unlawful search. The Commonwealth, as you know, for the first time on appeal, claims that Mr. Magri abandoned the bags. It certainly, not only did he not abandon the bags, but that the Commonwealth specifically disavowed abandonment as a basis for the search. The defendant asked, is there an abandonment, wanted to bring in other witnesses if there was the allegation that he abandoned the bags, and the DA says, no, I'm not raising that, and the court said twice that they have no basis for raising it. And so, there's no consent, there's no search warrant, there's no abandonment, so there's no basis, and I argue that, of course, that there's prejudice in this. Also, the Commonwealth also argued on appeal a disturbing reason for the legitimacy of the search, and that's that the defendant no longer had a reasonable expectation of privacy because he was arrested and knew he couldn't go back to them, and then thought, well, anyone could go search through them, even the police. Well, of course, if the court accepts that argument, then it means that anyone who is arrested, and because the government is now preventing them from reaching their possessions, now no longer has a reasonable expectation of privacy in those possessions. That certainly can't be the law based on public policy reasons, but also there was a case cited by the defendant. It was a case that had facts specific to this case, which is that the defendant had stayed overnight just once with a girlfriend, was arrested by the police, and was not able to go back and get his bags. That is United States versus Wilson, cited on page 19 of the defendant's brief. And the court certainly never held, the federal court certainly never held, well, of course he no longer has an expectation of privacy because the government arrested him and he couldn't go back to his host's house and retrieve the bags. So for those 2 reasons, obviously public policy, clear violation of the Constitution, but also precedent. I'd also like to get to the second argument, which is the joinder of the multiple charges. He was charged with 32 counts. They spanned June, July, and August. They involved multiple victims. They were different kinds of crimes. It was receiving stolen property, residential burglary, burglary of a car, larceny from a store, and credit card fraud, larceny by false pretenses. And this was all thrown in, as the defense attorney argued, this is taking any charge you can think of against Mr. Magri and just throwing it all into the mix and charging him.
Well, these are all property crimes designed to obtain quick cash on the street. Was there any evidence of motive? What motivated these crimes? It was drug use, right?
Yes, it was.
Purchase drugs.
Right, but that is not enough, and certainly case law holds that simply because someone wants to get money from committing their property crime doesn't mean that the crimes are related to the point that they can be joined when they're otherwise unrelated.
It's a summer spree. It's a whole series of crimes, all directed at getting items to resell on the street quickly to get get money for drugs. I mean, isn't that enough of a scheme and similarity to bring these together?
It's not. For a couple of reasons, it's not. Just using Massachusetts law itself, the statute itself, the Mass Rule of Criminal Procedure 9A1, states that you can join criminal episodes if they constitute parts of a single scheme or plan. These weren't part of a single scheme or plan. These were someone who wanted money for drugs and was committing whatever crime he could to get money for drugs. That's not a single scheme or plan.
What period of time did they occur in?
It was June, July, and August of 2007.
Now, what was the defense in this case?
What was the defense? It was it was mistaken identity with Miss Kim, the woman who took some of the jewelry and such, saying that she was only pointing at Mr. Magri because it was implied that she was going to be charged with running a pawn shop when she wasn't licensed to. That the two co-defendants were lying when they said that he had committed the crimes, that it was they. In fact, that's how they were cross-examined. It was you who broke into these houses. It's you who stole these items.
And would the allegations of other crimes be relevant in view of that defense?
No. Because mistaken identity is just that goes to that one witness. And what would have been more appropriate is one of the ways in which case law in Massachusetts talks about why it would be appropriate to join cases is if evidence of the other offenses would be admissible in separate trials, and that wouldn't be the case here. If you were doing the receiving stolen property cases, you wouldn't bring in evidence that he leaned into a car to rummage through the glove box to see if there was anything valuable in there. You wouldn't bring in evidence that there was a knife or razors or camera shoplifted from a store. Totally irrelevant. Likewise, if you were doing the larceny charges, and certainly you could argue that they should have all been tried together, the larceny because of the common and notorious thief, but then you wouldn't have the receiving stolen property charges, which tended to be very emotional. Stealing from stores is one thing, but the people would come in and they talk about what was stolen. It's something that was handed down by their mother who just died, or one woman talked about her son who bought her a ring and he's now in a coma because he's a soldier. I mean, these are very, very heart-rending statements, and they came in on the irrelevant crimes, the shoplifting, and so what happened was you had him portrayed as someone who was quite despicable, when in fact what the jury was supposed to look at was, did he actually commit this particular crime? Do we have enough evidence of the elements of this particular crime? Not, was he a despicable person?
Maybe I missed this, but did the crimes all take place within a reasonably restricted geographical area?
Pittsfield.
Well, but within an area?
Yeah, yes.
Was it like a neighborhood of Pittsfield, or?
Yes.
Or was it just sort of greater Pittsfield?
Well, my understanding is that it was Pittsfield.
Uh-huh.
Yeah, but I didn't specifically look. It was in either Pittsfield or right around there. But
Okay.
I know I stated in the brief that it was Pittsfield, and at this point I'm not quite sure how clearly I
Field
determined.
is of some size.
Is it? Yeah, well, I think it was Pittsfield. But I also like to point out, it's quoted in the brief, the court talking to the prosecutor when they're trying to do the jury instructions, talking about he doesn't know how the jury is going to be able to get through all these jury instructions. It's very confusing. It's going to be massively confusing. And so it was just too much. The ability of the Commonwealth to sort of save time by having just one jury. This was a multi-day trial. I'm not sure that, and the jury was picked in half a day. I'm not sure that the length of the trial would have been any longer if there were just 3 separate trials where the prejudice was not there from the multiple.
Right, but you still have to deal with the fact that the jury did acquit him of 4 of the counts.
They acquitted, and in one respect, I have no idea how they did that, but in another respect, that might be for confusion. That might be to say that they weren't confused, but that still doesn't go to the prejudice of having him portrayed to them as committing all these crimes, and he was acquitted on the ones where just the co-defendants, who were equally despicable and had a great motivation for testifying. They could have gotten life sentences if everything had been consecutive, but we're hoping for, at least the woman was hoping for probation. So that, I think, you can take out those 3, and I don't think that really shows that they weren't confused on the others. Also because there were a number of charges where they don't list, in the identity fraud, they don't list whose credit card it was, whether it was a credit card, and so I have no idea how they decided that he was guilty on them.
Ms. Caddick, your time is
Okay,
up.
thank you.
Thank you.
Good morning, Your Honors. Chief Justice Ireland, Justices, Madam Clerk, may it please the Court. My name is Joseph Piropan, Assistant District Attorney for the Berkshire District. Let me first address the search and seizure issue by saying that the Commonwealth, contrary to what counsel claims in her brief, does not rely upon a theory of abandonment. And I say that most sincerely because, unfortunately, the motion hearing, the motion to suppress was rather of a summary nature, I should say. One witness testified. The Commonwealth presented the officer's testimony, the signed consent form. Most of the questioning post-testimony was done by the court to defense counsel. And at that point, the Commonwealth indeed explicitly, and we do not hide from this, say we are not relying upon abandonment when the issue of the stolen air conditioner was raised. 2 things about that. The issue of the stolen air conditioner appeared on cross-examination of the officer. It was never part of the Commonwealth's direct examination. And I suspect, and I wasn't there, but a fair reading of the motion transcript would indicate that Officer Kirchner, who was not the officer that wrote the report, Officer Sewells wrote the report that the defendant provided in her appendix. He accompanied Sewells. He testified. He didn't author the report, but he did say, in response to a question from counsel, and this is on page 19 of volume 3 of the motion transcript, quote, so apart from that, namely the stolen air conditioner, did she, Mrs. Barnes, indicate to you, Officer Kirchner, that he, Mr. Magri, wasn't welcome in her apartment? And the officers replied, yes, because of the stolen air conditioner. And that was it. The point I'm trying to make here is that that information is introduced in a most spontaneous method. Now, understandably, it was not included in a police report, but the defense counsel chose not to call a witness to pursue an abandonment theory, because it wasn't abandonment. The point here is simply this. Mr. Magri's, the defendant's expectation of privacy, was minimal at first when he entered that apartment for a couple of nights, and it disintegrated to virtually nothing upon Mrs. Barnes, the owner of the apartment at White Terrace, learning 2 pieces of information. One, when the police arrived, Mr. Magri had been arrested for being a thief. And number 2, she voluntarily told the officers, by the way, tell him not to come back here. He stole my air conditioner. She effectively terminated his stay at the premises.
So how do they get into the bags? How do they look into the bags?
Because once the officers have the bags in hand, in essence, the defendant has surrendered his bags, his expectation of privacy in those bags to the lawful occupant of the apartment.
So it's as if she put them out on the street line.
It is as if she put them out on the street, because what she is doing is she is surrendering to the officers the property that Mr. Magri had placed into her home.
Aren't you treating it very much like the Molina case? About the hotel in Boston?
Well, yeah, I'm glad you pointed that case out, because I just read that case yesterday, and one point I wish to draw an analogy to is that in Molina, in which the guest of the hotel, I'm struggling to classify him, the guest of the hotel signs the agreement that says, oh, by the way, the hotel can kick me out without notice. Right. For good cause. And of course the court found that given Molina's behavior, that it was known to both Molina right. and to the hotel, right. and the subsequent information learned by the hotel, they double locked the door. And Molina says, oh, by the way, I paid up until the 20th. My expectation of privacy didn't elapse until the 20th. And this court said, oh, on the contrary, you're on notice that your tenancy or your stay at the hotel could be terminated without notice to you, Mr. Molina. Well, similarly here, we know several pieces of information about Mr. Magri. Number one, when he's initially arrested, not on August 9th, but on several days prior, and placed in protective custody, I believe, he claims he's homeless, so he has no home. Only after police surveillance indicate that he has spent a day or two, Ms. Barnes characterized it as a couple of nights at White Terrace. Do the police go there in the expectation of finding?
But you know, the facts are very different in our case, in this case, and that hotel case. In that hotel case, first he had signed something, but they had also had a conversation with him in which they said to him, if you keep doing this, you can be terminated.
He had been warned.
So he had been warned.
I agree, Your Honor.
Unlike this case.
But here, Your Honor, the point I wish to draw is this. In the case the Commonwealth relies upon is the Mallory case from 1999, I believe. It's cited in my brief, 2002, actually. It's an appeals court case. In Mallory, in which the defendant, this is the case in which the defendant was basically, chased out of the room, out of the house by the baseball bat wielding father of the young lady that he had sexually assaulted. In that case, the court found that whatever expectation of privacy the occupant had in the premises disappeared once his status became terminated.
But did you argue consent in the trial court?
Well, absolutely. That's how the police get in the building.
Well, but I mean, how could she consent to them taking property that she essentially said, look, it's not mine. As far as I'm concerned, this guy's out of here. I mean, she's not really consenting, is she? You're relying on a different theory now. No,
actually, Your Honor, this is again why I draw the analogy to both Mallory and to Molina. When Mr. Magri has essentially, through his own action, caused himself to be not welcome at the premises, he has surrendered any expectation of privacy in those packages.
Did you argue that below?
Well, unfortunately, in the record of the motion, no argument was made. The Commonwealth simply offered the consent, and the court took it under advisement. And in the court's findings, they found the expectation of privacy had been minimal, and that the occupant, Ms. Barnes, had full authority to consent to the police not only seizing the property, but also searching it. Similar, and this is very much like what we see in both Molina and Mallory, in that for constitutional purposes, reasonable objective societal expectations are to be considered here. This is not a unilateral action by Mrs. Barnes. On the contrary, the defendant, Mr. Magri, by his own action, had extinguished his welcome at that apartment.
Well, had that been communicated to him, he could have made arrangements to have someone pick up the property.
Well, but in that situation, is that possible? Yes, that's possible. Unfortunately, because he is under arrest, and the Commonwealth isn't arguing that solely because he's under arrest, he has abandoned the property. On the contrary, that fact is known to Mrs. Barnes, and he's under arrest. He's not coming back, and she furthermore says, and by the way, tell him if he makes bail not to come back here. So his stay at that residence has been terminated.
Can we move to
It's
another?
not, oh, go ahead.
I mean, can we move just to another point? Well, let's assume we don't accept your argument and we conclude that the search of the bags was not proper. How does that affect this case? Should all of the convictions be reversed? I mean, you asked that they all be tried together, so to a certain extent, they're all in the same bathtub here. Or do you have a different suggestion?
Well, two responses to that, Your Honor. First of all, in terms of the sentencing structure, I believe the defendant received consecutive state prison sentences. One batch serving, one series serving consecutive to one other indictment. Even if this evidence were to be suppressed, and if the court were to maintain the other convictions, the sentencing structure, I do not believe it would be upset. Getting back to the court's point, if indeed this evidence is suppressed, what prejudice to the defendant? I would suggest that given the sheer volume of the evidence against him, in fact the police had him under surveillance, they caught him breaking into a car, that's why they arrested him actually. And by the way, that was, I believe, the seminal 4 to 5 state prison sentence. Notwithstanding, as counsel has pointed out, the jurors may have discredited or disbelieved or chose not to credit the co-defendant's testimony. The evidence was pretty strong, especially by Mrs. Kim, that he had fenced the property with her. And so I would suggest that the prejudice would be of minimal harm to the defendant.
On all of the other charges on which he was convicted that
Yes.
don't relate to the things found in these bags?
Well, there was in excess of over a dozen victims, well in excess of a dozen. I believe only 3 or 4 victims were named. Their property was found in these bags. And unless the court has further question, I'll rest upon my brief.
Thank you, sir.
Thank you very much for your time.